I'm glad to be present at the first meeting of the high-level forum on the future of the EU criminal justice. I welcome the joint reflection initiated today, which aims at covering a broad range of topics from substantive and procedural criminal law, judicial cooperation, to the role of the EU agencies and bodies, as well as the potential of digitalisation in the justice system. The setting up of this high-level forum is fully aligned with the calls of the European Parliament for a more coherent and high-quality EU approach to criminal law, which, and I quote, should contribute to the development of a common EU legal culture in relation to fighting crime. Well, this can only happen if the Commission, as initiator of legislative proposal, the Council and the Parliament, as co-legislators, discuss together such matters. Exchanges with independent experts and practitioners do contribute to a more comprehensive, informed overview with regard to any further steps to be taken with a view to ensuring coherence in EU criminal law. I welcome the common reflection and remain convinced that our diverse roles and backgrounds representing the EU institutions, agencies and bodies, practitioners and academia will enrich the debate. On an institutional note, my presence today on behalf of the Committee of Civil Liberties, Justice and Home Affairs, which I chair, is limited to these kick-off remarks, as the Parliament has yet to decide whether it will follow this reflection throughout the reflection process at a political level. Let me now briefly refer to the first topic that will be discussed in more details this afternoon, EU substantive criminal law. I would like to mention here that the draft model provisions that the Council shared with the European Parliament in December 2024 as a basis for further interinstitutional exchange. Political groups have discussed them and the LIBE coordinators endorsed them last month before we shared them with the Polish presidency of the EU Council. I have to stress once again that any model provisions of EU criminal law remain for us of a non-binding nature and cannot affect the prerogatives of the three institutions or preempt policy choices that they might make in the future. Having said this, the LIBE Committee stands ready to further exchange on the matter in order to find the most suitable way of endorsing together such model provisions, mindful of the sensitivity of substantive criminal law, but also of the technical nature of such an exercise. More generally, I would like to stress that the harmonisation of EU substantive criminal law should contribute to the development of a common EU legal culture in relation to fighting crime and should have a positive impact in the mutual trust among Member States. We are aware, however, that such harmonisation adds up to, but does not substitute, national legal traditions as the treaty recognises them. On this basis, we look forward, as LIBE Committee, to work together with you towards a more consistent EU criminal law. When it comes to the future of judicial cooperation and mutual recognition, as well as to the future of procedural safeguards on the agenda for tomorrow's sessions, I have noticed the ambition of covering a wide range of topics. Allow me to make some general remarks without prejudice to the more extensive discussions you will be having. Firstly, I believe that discussions should be framed with due consideration to the Treaty of Lisbon provisions, which significantly changed the EU's constitutional configuration and provided explicit legal basis for rules and procedures ensuring the judicial cooperation and mutual recognition in line with the political guidance formulated by the 1999 Tampere European Council. I would suggest to the participants to this forum to keep in mind a potentially guiding question. Does the current EU legal framework, as based on the Treaty of Lisbon and as applied in practice, reflect the ambition of Tampere, namely creating a genuine European area of justice? Well, I believe we make great progress. However, we shouldn't miss the chance to explore ways to improve what's already in place. This could This could mean better implementation or, when needed, introducing new legislation, always keeping in line with the principles of subsidiarity and proportionality. Secondly, may I recall some of the statements and pleas the European Parliament has already put forward, particularly in its report on the implementation of the European arrest warrant and the surrender procedures between Member States, which was adopted by the European Parliament in December 2020, and we think they are still relevant today. Mutual recognition requires a high level of mutual trust between Member States. That's obvious. And is a consequence of it, based on a common understanding of the rule of law and fundamental rights. We believe the reinforcing trust is key for the mutual recognition instruments such as warrant to operate smoothly. Such mutual trust only be achieved if respect for fundamental and procedural rights of suspects and accused persons in criminal procedures is guaranteed throughout the Union. Therefore, the importance of implementing the Procedural Rights Directive should be recalled with a view to guaranteeing the right to a fair trial. The Commission was urged by the Parliament in this regard to ensure the full and correct implementation of these directives and to consider launching infringement proceedings where necessary. Mutual trust also requires Member States to be compliant with the EU law, and in particular with the fundamental rights recognised by the Charter and the rule of law, such as the judicial independence. Providing for a coherent policy on mutual recognition should also take into account the case law of the Court of Justice and the current level of harmonisation of Member States' criminal law and procedures. In this regard, I would like to recall the extensive discussions on the matter held under the Polish presidency at the Justice informal ministerial meeting in January 2025, and at the same time, let me also stress, in line with the Parliament's report of 2020, that judicial rulings cannot become a substitute for well-drafted legislation at Union level. On a complementary note, Parliament called for legislative instruments on procedural rights, such as those on admissibility of evidence and prison conditions in pre-trial detention, in particular on the basis of Council of Europe standards or higher, including with regard to time limits on pre-trial detention. These pleas are not new. More than a decade ago, by its resolution of the 2nd of April 2014 on the mid-term review of the Stockholm Programme, the European Parliament had already called on the Commission, and I quote, for establishing such standards in relation to pre-trial detention, administrative detention and detention of minors through legislative action, end of the quote. And for the admissibility of evidence, setting up common standards would be extremely important for the final judgment at their mutual recognition. When it comes to European arrest warrant, Parliament acknowledges that this has been generally a success. However, addressing its shortcomings is a necessary process. Particularly, the Parliament pointed out to some of these shortcomings: uneven application and refusal to surrender based on internal legislation grounds, which provided for in the framework decision. In this context, it's also important to stress that instruments such as those related to the transfer of prisoners, probation and alternative sanctions, the European Investigation Order, the European Supervision Order, both complement the European Arrest Warrant and provide useful and less intrusive alternatives to it. The European Parliament has therefore urged Member States, where possible, to use such alternative instruments instead of issuing a European Arrest Warrant. Should such alternative instruments need modernisation and adaptation to the post-Lisbon setting, the European Parliament would be extremely interested in looking into the matter. On top of that, addressing the shortcomings of the European arrest warrant in connection with the other instruments should comprise a combination of practical measures, such as training of practitioners, soft law, handbooks and recommendations, but also legislative changes, reflecting some of the relevant developments by the Court of Justice case law. Given the, additionally, a union of equality must ensure protection for all victims of crime, while also protecting the rights suspects and accused persons. I am confident that the interinstitutional negotiations referred to by Minister Bodnan on the amending Victims' Rights Directive continue to advance smoothly and would bring enhanced protection and genuine remedies for the victims. I can assure you that Parliament is fully committed to these interinstitutional negotiations. Given the complexity and the extensive legislation adopted in the field of EU criminal justice on the medium and long term, the promotion of an EU judicial cooperation code in criminal matters that systematically gathers the existing legislation to guarantee legal certainty and the coherence of the various EU instruments could be envisaged. It's important also to discuss what can be improved, but also it's important to be aware of the crucial role of the Commission and the need for a robust approach in assessing and reacting to the breaches in areas such as mutual trust and the uneven application of these legal instruments. To conclude, I think once again the Commission and the Presidency of the Council for initiating this joint reflection process. I am confident that this forum of discussion will allow for a fresh and bold look and serve as basis for further action aimed at consolidating a genuine European area of justice. And I do look forward to continuing our joint reflection. Thank you very much.